This is not some constitutional decision. That's what your lordships, supposing your lordships were to say that they can change the definition, or your lordships were to say.
But therefore, the ultimate question is whether the Constitution does or does not interest that authority.
That's correct. That's all that I'm asking, Miller. I'm not asking for anything more.
And which in turn depends on whether 370 is construed as you say, a permanent feature, irrespective of the terminology used, because that is in the context of the changes till the Constituent Assembly was there, or is it something which is capable of being?
Well, let me see. That's a much higher level, Mullahs, to which I'm not, in fact, arguing that today. Mullahs, whether it is permanent or it is temporary, let's forget about it. The central question is, can the Union of India, in this manner, terminate that relationship that is constitutionally recognized in Article 370?
You understand?
It may not be permanent. It may be permanent. It may not be. You may change it. You may. You may have.
In the context that that was the argument earlier. So we have come to the next argument, which is the manner in which it is done.
That's right.
Is flawed accordingly.
It's absolute. It's a fraud on the Constitution itself, according to me. It is politically motivated. It is a political act. These executive orders are political acts. They are not constitutional acts. That's my submission. And whether it is a permanent feature or a temporary feature is really, at the moment, not an issue. The reason why it's not an issue is maybe there is a constitutional way of doing this. I'm not addressing that. Nor have they resorted to that constitutional methodology. If they resort to it, it will be tested in a court.
And on the process, you said last time that, first, the Section 92 power was vested in the governor,
yes,
independent of the Council of Ministers.
Step 36, 38.
Right. Step 2, right. Step 2, the Legislative Assembly is dissolved by the governor under Section 53 without aid and advice.
Yes.
3, the proclamation is issued under Article 356.
Yes.
You said that the object of the proclamation under 356 to eventually restore democracy.
That's right.
And not the decimation of democracy.
Right.
And then finally, we saw the amendment of Article 3 in the presidential notification.
That's right. That's also an executive act.
All these 4 steps, according to you, were constitutionally flawed. There was no provision for these 4 steps because you've essentially taken away the powers of the State Assembly and exercise them under the garb of 356. That's the submission.
That's right. Absolutely, I'm deeply obliged to your lordship. But I just want to read one other.
Only one last thing which I wanted to ask you. You made your point on the process which was followed. They will have to answer it. On the proviso to clause 3 of 370, is there something ultimately that happened in the Constituent Assembly which sheds light on which way the Constituent Assembly was inclined to go?
Yes.
Because we are reading individual speeches. What happens thereafter at the end of this process in 1957?
The Constitution was adopted in 1957.
Yes.
By the legislature of Jammu and Kashmir. Between 1951 and 1957, they could have determined or terminated the essence of Article 370, abrogated it themselves, and said, there's no need for this Constitution. We want to be a state, a part of India, like any other state. That is why 370 sub-article 3 referred to the decision of the Constituent Assembly. That decision could have been taken. But my lord asked me the question, well, now that there is no Constituent Assembly, how will this happen? If it were deemed to be a temporary provision. That's what my lord put to me. Right?
So your argument would be really, if I can put it that way, that the proceedings in the Constituent Assembly of the state of Jammu and Kashmir would indicate a reaffirmation of the arrangement under Article 370 as a long-term arrangement.
That's right.
So that the 3 options that Sheikh Abdullah spoke about, namely either of joining Pakistan, acceding to India, or remaining independent, they gave up the first and the third option.
That's correct.
They decide that the ultimate decision was to stay within the dominion of India, but subject to the safeguards of 370.
That's right.
And therefore, according to you, 370 assumes a permanent character, irrespective of the nature of the provision which is envisaged in the Indian Constitution.
And that's what Sheikh Abdullah said in his speech, that look, this relationship...
That still begs one question as to whether it was enough that the Jammu and Kashmir Constituent Assembly proceeded on that basis. Put 370, which was envisaged to be a temporary provision be converted into a permanent provision merely by the proceedings of the J&K Assembly? Or was there some further act required from the Indian Constitution, either in the form of a constitutional amendment, by virtue of which 370 would cease to have a temporary character but have a permanent character, in implementation of the wishes of the Jammu and Kashmir Constituent Assembly?
Whereas Government of India never expressed a contrary opinion throughout.
But didn't it have to take place through a process of amending the Indian Constitution itself?
No,
To
for the
convert the
reason-
character of 370.
All right, Maharaj, now your lordships are again going back on the issue of temporary nature. That temporary nature is not part of the Article 370. It's not part of it. It's not a part of 370, Maharaj. In fact, Muzaffar Beg says we didn't even know about it. That's why I want to read Muzaffar.
Mr. Sibal, there are two ways that we could really lead into this discussion. One, that though placed in Part 21, Article 370 was never intended to be a temporary provision. That's one. That's one layer of reasoning, which is what you're advancing. Two, that though it was temporary, the reason why it was placed in a temporary provision of the Constitution was pending the decision of the Constituent Assembly of Jammu and Kashmir, and therefore it was given the character of a temporary provision, because the views of the Constituent Assembly of J&K were still to be elicited.
Right.
Third, that's the second argument. We accept that for the purpose of hypothesis. The difficulty, of course, which we have to face is this. Assuming that that was why it was placed as a temporary provision, because the views of the J&K Constituent Assembly were still to be elicited. And we also take your point that the J&K Constituent Assembly decided to accede to India and reaffirm the accession to India subject to the safeguards of Article 370. Is that sufficient in itself to convert 370 into an unamendable or untouchable provision?
Let me assume, Maharaj, that it is
Or
not.
was something more required by a parliamentary intervention in India post-independence to convert that which was essentially temporary into a permanent provision?
Let's assume, Maharaj, that it is amendable for the sake of argument. Then, Maharaj, how is to be amended? The Constitution must provide a solution, no, Maharaj? I'll assume, Maharaj, for the moment that it is amendable. Then how does the Constitution of India must provide a solution for that?
Once we concede, Mr. Sibal, that concede in the sense for the purpose of the hypothesis. We're not putting anything in your mouth, not at all. So I don't misunderstand that. Once we accept the fact that 370 is subject to the amending power under 368, then equally 370 provides for a modality through which 370 itself would come to an end.
Well, let's see 370 then, Maharaj, and see what modality is. That modality can't be to convert a legislative assembly into a constituent assembly by definition through an executive act under 367(1). Then, Maharaj, we have to find the modality within the Constitution, not outside it, not vested in an executive power of the Union. That cannot be. So if your lordship puts to me, and rightly, that something more had to be done under the Constitution of India, we'd like to know what is that something more.
But 370(3) itself specifies the conditions in which the abrogation can take place.
Which is the Constituent Assembly it must be on the recommendation of the Constituent Assembly. So it gives the solution. That is in line with the federated nature of this provision. This is complete federation, whereas we are quasi-federal qua other states. But these are purely federal qua Jammu and Kashmir, because the residuary power vests, Maharaj, in the state. So if you say, Maharaj, that C70 sub-article 3 provides that solution, but that is provided, certainly, but upon the recommendation of the Constituent Assembly.
And therefore, according to you, the power is completely lost once the J&K Constituent Assembly comes to an end.
Let me even not go that far. I'll assume that there is some power available. It may be 368. Let's say, it's hypothetical. We're not concerned with it.
No, Mr. Sibal, no. When you argue, then we'll have to take one. 360 is power to amend the Constitution. That's certainly there.
Yeah.
Now, when we look at 370, clause 3. Now, the issue would be whether 368 power is still available to amend the constitution.
Well, your lordship is not concerned with it in this matter.
No, it is. It's very, very crucial. Because once we accept the fact that Parliament as a sovereign lawmaking body has the power to amend everything, including 368.
Yeah.
370.
Including 370.
Yeah.
Then any amendment of 370 may be subject to criticism on the ground of morality, but not power.
No, but it's not an action.
Maybe it's a political argument, but not a power. It's not an argument of constitutional power.
This is not action under 368. Your lordship is not going to hypothetically say this is an action under 368 when 360 has not been invoked.
But then likewise, the exercise of power under 370 bracket 3, can it not be then criticized? It's a question of criticizing it as a political criticism. But is it an argument of the absence of power?
Where is that in 370?
And the court is concerned with either the existence or the absence of power, right?
Not that I should ask your lordships, where is that power in 370 that says that 368, you can do it under 360?
So 368 is the power to amend the constitution.
But we are not, are we concerned with that here? I'm sorry, Malaj, you require 2/3. You represent.
There are independent avenues. You have the power to amend.
Malaj,
you have the power within 370 to abrogate.
But Malaj, in that independent avenue must conform to the provisions of the Constitution. Well, an independent avenue derogates the provisions of the Constitution, is no avenue at all.
Mr. Sibal, for the timing, if we ignore the proviso to clause 3, in fact, the clause 3 itself, independent of the proviso, gives the power to the president itself to abrogate 370.
No,
if we forget about the
sorry.
proviso.
I'm sorry to say that, Malaj. I'm really
Just
sorry.
read
There is a
just read it
proviso.
once again. Just read
You
it
can't
once
exercise that power without the proviso.
No, the proviso is something different. We are examining the proviso independently. But independent of the proviso.
Clause 370 comes into play on the recommendation of the Constituent Assembly. Your lordship is putting it the other way around. It comes on the recommendation of the Constituent Assembly that the president will exercise power, not the other way around. That's why I said you can't even initiate a bill. Your lordship will remember that. You can't even initiate a bill. Forget about anything else.
Another problem is that then we would be redrafting the substantive part of clause 3 to postulate that the power under the substantive provision of clause 3 can be exercised so long as the Constituent Assembly of J&K is in existence. In which case, will the proviso not swallow up the main provision?
But that's what it says, that unless that recommendation is there, you can't exercise your power. President can't exercise power under 370, sub-article 3. It says so. Well, you'll have to interpret it on its plain terms, Malad, and the lordships have said it not once but several times over. And it's a provision which, in essence, is a provision of federalism. It's at the heart of federalism, is this, Malad. Yes, of course, it's a precondition. There's no doubt about it. I mean, whatever sophistry may happen, can't happen in this way, Malad. And whereas 373 power has been exercised by the Constituent Assembly, saying no recommendation. And I'll come to your lordship's judgment of Sampath Prakash Maras, which actually deals with this issue. So let's be clear, Maras.
Where does the Constituent Assembly specifically says that it doesn't the sub-article 3 will not apply to the, it only says that it only exercises the 3 choices. First, as to whether it should accede to the Pakistan or to India or to remain independent. So out of 3, it decides that it will accede to India. But where does it specifically say that it recommends that sub-article not be available?
Let's go back. Let's go back, Malas, to 1950, 26th of January. Right? There was no Constituent Assembly. In fact, there was no decision. Originally, it was a National Assembly. There was no decision to convert it through adult suffrage into a Constituent Assembly. So Parliament, forget about the government, Parliament incorporated in 370 the provision for a Constituent Assembly. I asked myself this question, why? Why did Parliament do that? Parliament did not, there was no Constituent Assembly in place. There was only a National Assembly. This must have happened in collaboration with Jammu and Kashmir. Must have happened, Mullahs. That's why the term Constituent Assembly was included in 370 sub-article 3. Now, when they said in the proviso that it's on the recommendation, there was no Constituent Assembly. So it had to be a temporary provision. It couldn't be a permanent provision. And the preamble of the Constituent Assembly says to further define the relationship between Jammu and Kashmir and India. So it was temporary because there was nothing in place. It was not temporary because this provision had to go. No. And therefore, Mullah, that relationship was to be decided by the Jammu and Kashmir Constituent Assembly, which had to affirm all laws that had been passed. Even the laws could not be passed till such time it were ever confirmed during this period by the Constituent Assembly. So the Constituent Assembly actually was exercising a dual role at that point in time. And the government of India in 1950, in Parliament, recognized that it is the Constituent Assembly on the recommendation of which 370 will be abrogated. There would have been no constitution of Jammu and Kashmir. Let's put it that way. There would be no constitution of Jammu and Kashmir, Mullahs. If 370 had been abrogated, it would be yet another state of India.
Mr. Sibal, you've made your point now. I think basically as we see it, your argument is in three layers. We looked at the background, the history. We look at 370 in the background, the constitutional history, the other history which we saw pre-independence. We interpret 370 therefore in the context of that history, and then we've gone to the modalities which were followed for abrogation, which you have said is unconstitutional. Now, after having explored this terrain,
Let's
which is the next, how do we now progress?
Come back to the list of dates, Mullah.
Right.
Well, with your 2 minutes I'll take. There is a speech by M.A. Beg, Afzal Beg. Just it'll take only.
Just give us just the page and the gist of it, you can tell us.
At 694, PDF 694. It's only temporariness of the article. That's why that's the last person. You need not go through it. It refers to the temporary nature of the article.
It would be in the same vein as Mir Qasim's speech at 648.
And Mullahs, kindly note this, he was a representative of Jammu and Kashmir in India's Constituent Assembly. There were 3 members total. He was one of them. So he was part of the Constituent Assembly of India as well. I said that a good deal of criticism was leveled in both houses of Parliament of India and in the outside press in regard to the intention of 370, that it is a temporary article and the special position of Kashmir ipso facto is of temporary nature. This raised doubts and suspicions not only in the minds of the people of the state, but also in the minds of our colleagues sitting in this house about our relationship with India and Kashmir had peculiar position in 1947. It has now. That peculiar position is a permanent character of the state. It would be unfair to say that this position is a temporary nature. Statements have been made that in due course of time, 370 will cease to exist and Kashmir is bound to become a Part B state. Expressions like these have in fact given rise to amendments proposed by honorable members to the statements of the Leader of the House. Some of these amendments are critical and some are unfriendly. And then he goes on to say that we did not even know that there was a note, a marginal note in this regard. This has just come up suddenly. We didn't know that there was a margin. Nobody told us that there'd be a marginal note. So anyway, that's all that he says. I just wanted to invite my Lord's attention. So in my supplementary submissions, only I have set out these passages, nothing more than that. And so last try, so long as it is not completed, Article 370 will remain there. And when it reaches completion, we shall give to Paul what Paul's and what gives to Peter what Peter's. This is the center. that is, center will have the exceeded subject and the rest will remain here. 370 will have to be accordingly altered. It would not mean that Kashmir state will cease to have its special position. Amending 370 may be necessary at the time when we finalize our constitution. But even then, legally, constitution as it cannot in any way rob Kashmir of its special privileges and position given to it by common agreement. 370 is therefore temporary till we complete our constitution. That's the spirit with which it was incorporated into the Constitution of India. This is the point, Malak. Anyway, Malak, so that's what I've done with this. Now
Yeah.
kindly come back to the list of dates.